But the item number 47 and 48, but item number 47 and 48 of the subject.
47 and 48, yes.
So for the 47 is concerned, madam, today morning I have been engaged, madam.
Hmm?
Today morning only, madam, I have been engaged, madam.
Hmm.
But the matter will be taken about, madam, the 22 or 23, madam. So for the 48 concern, madam, she is appearing, madam. I've also taken the concern of the informant side.
You are appearing for 47.
47,
48 you are appearing. So you want it to be listed on
22 or 23.
CD has been received, Lordship.
CD has been received. Okay. Right, on the prayer of Mr. S. Botthakul, the learned counsel appearing for the accused applicant. The matter is adjourned to 24th. Mr. Botthakul submits that he has been recently engaged in the matter.
Can it be on, madam, the
Let the
23?
matter be listed along with item number, along with AB number 11592026. 2626. CDs received to be retained.
Or can it be on 22 or 23?
24 times saying,
24, I'll be out of this.
23rd. 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 MS so appears for, your name? S code appears for the petitioner in, the accused applicant in AB 1159.
Yes, this is the lordship. Lordship, I beg to mention item number 9.
Hmm.
Can it be taken up after 2 weeks? Sir?
Hmm?
Item number 9, my lord.
Yes.
Can it be taken up after 2 weeks, my lord?
Your name?
MA Chaudhary, my lord.
On the prayer of Mr. M. A. Chaudhary, the learned counsel appearing for the accused applicant, let the matter be listed on.
Any date for the
After?
After 2 weeks, my lord.
Why 2 weeks bail application?
Just my the issue is 36 and
Huh?
36 issue is there also in this application, my lord. And this has been referred, my lord, to the
Okay, let the matter be listed let the matter be listed after 2 weeks. The adjournment is granted due to the reason that the issue involved in the bail application is in reference before a division bench.
date of the-
Please, madam. Item
Hmm?
number 4. I beg to mention item number 4.
Item number?
41. On behalf of Mr. S. Samaria, my lord.
Huh?
On behalf of Mr. S. Samaria, my lord.
Hmm.
My lord, I have taken consent of the other side, lord, in this matter.
Who is the other side?
I think respondent number 2, my lord.
Huh?
Respondent number 2, my lord.
Who is respondent number 2? You have taken consent from whom?
Mr. Samaria, actually, my senior taken consent from respondent number.
No, you should be instructed, no, whom you have taken consent from. In 2016 matter?
Yes.
Huh? Why adjournment should be given in this matter?
Personal difficulty.
What personal difficulties 2016 matter? 2016 matter you are seeking for adjournment?
Just for one.
And from whom you have taken consent?
Lordship, respondent 2. Respondent.
Who is respondent? Who is the lawyer? 2016 matter, this is not the way to do it. This is not the way. This is not the way to seek adjournment for a matter of 2016. What personal difficulties your senior has? Hmm? There are other counsels there. What is your name?
MM Zaman.
Hmm?
MM Zaman, lord.
And you are not, you haven't signed the wakalatnama also.
Okay.
Where is your senior?
This, actually, one of his family member is admitted in the hospital.
Okay, right. Mr.
MM Zaman, lord.
M. Jaman appears on behalf of Mr. S. Chamaria. He prays for adjournment of the matter due to personal difficulties of Mr. S. Chamaria. Taking into account that the matter pertains to the year 2016, the last opportunity has been given. Taking into account that the matter relates to the year 2016, The matter is adjourned for 3 weeks. No further adjournment shall be given in the incident case.
Permission, may I pray for listing of two anticipatory bail applications pertaining to Itanagar Bank, tomorrow, madam.
There is a senior bench, probably. Is there any senior bench?
Yes.
You go to
Yes,
the
yes.
senior bench. You go to the senior bench.
Special acts, your lordship is, under special acts, my lord, the cases, your lordship is,
Special acts, which act is this?
my lord, this is prevention of corruption.
Itanagar bench, why you are mentioning here?
There are two ongoing vacation, my lord, to the Itanagar bench. It will reopen on 20th.
It will be reopening into next week only.
My lord, it's an anticipatory bail application. We are anticipating arrest, my lord, we are public servants, my lord, executive.
Which act is this?
Prevention of corruption act, my lord.
Roster. So, okay, so it is. Okay, when do you want it?
Tomorrow, my lord.
Hmm?
Tomorrow, my lord.
Okay.
May I begin? I beg to mention item number 10, my lord. Item number 10.
Item number
10.
10.
It's a bail application. In this matter, we are going to file an objection.
Hmm?
Objection we will file for DRI.
You have intimated the other side.
Yes.
On behalf of S. Sarkar, yes.
Your name?
I'm for DRI PS Chakraborty.
Yes, Chakraborty, the learned counsel appearing for DRI submits that they are going to file an objection in the matter and therefore prays for how much time?
1 week time.
Prays for 1 week's time, which is not objected. The prayer is not objected by the learned counsel, Mr. S. Sarkar, appearing for the accused applicant. Full stop. Let the matter be listed after a week.
Regarding the item number 11, I am appearing on number 2, my lord. Instead we have filed an objection.
S1 number?
2, my lord. Inform me. So, my lord, instead we have filed an objection, my lord. This is the requisition and call for the same along with item number 11.
You're appearing for respond number 2.
Yes, sir.
You have instructions to appear for respond number
Yes,
2.
sir. Instead already we have filed the Okalatam also.
Okay. So you want to file an
Already
objection?
filed, but it is a call for the record, my lord, to be accepted.
They already filed.
Yes, my lord.
So you want it to be called?
Yes, yes.
Okay, call allow.
Yes. Item number 33, lord, sir.
33.
CD was called for. I have been.
He did not receive lots.
Okay, item number 33, Ajed Ahmed. Ajed Ahmed appears for the petitioner. CD is not received. Let the matter be listed let the matter be listed on 22nd.
Call for update.
Hmm?
Call for CD, lord, sir.
CD is already called for. CD is not received means what? CD was called for.
No, no, we have moved an IA for cancellation of bail.
Hmm?
Here, your lordship has granted bail, the
Hmm.
POCSO matter.
Hmm.
So this is for listing matters. And
Hmm?
IA for listing for IA. And IA, we want the IA to be listed,
IIT will step forward.
for cancellation of bail.
Cancellation of bail.
Tomorrow.
You are appealing for whom?
It's, we are making a fresh mention for listing matters. Mentioning for listing matters.
No, you are filing an
I'm filing on behalf of the
informant.
victim,
Okay, allowed.
much.
You withdrawing? Yeah, A.M. Khan. Mr. A. Mubarak, the learned counsel appearing for the accused applicant, submits that he has instructions to withdraw the instant AB application. The prayer of withdrawal is allowed. The matter is dismissed, the matter is dismissed on withdrawal.
Matter will be taken up along with item number 13. What are arising of the same FIR?
Same FIR, we have received the case.
13, man.
13,
Yes, ma'am. One, three. Item 45, also. Will be taken along with item number 19, man. Out of same.
19, 11, 19.
Obviously. 46.
May it please your lordship, out of same FIR lordship,
Hmm?
item 16 is there lordship. Item 16, 1/6,
Same, I mean,
out of same FIR.
same affair. Okay, 16.
Public.
16 or what? Huh? Ini bisa lang yan.
Item four.
Kung masa may mahina, no? Bisa lang. Yes,
Prayer for withdrawal also, as per
Hmm?
instruction of petitioner. Prayer for withdrawal also.
withdrawal. Your name A.R. Karim?
S.A. Mandal.
Huh?
S.A. Mandal.
S.A. Mandal. Mr. S.A. Mandal, the learned counsel appearing for accused applicant submits that he has instructions to withdraw the instant bail application. The bail application is dismissed on withdrawal.
Item 5.
Please, Your Lordship,
Hmm.
483 application also.
Hmm?
He was arrested on 31/1/26. Thereafter charge-sheeted. Even the evidence of the victim was recorded on 15th of June. Most probably it is behind the record
Is behind the bars
for more than 164 days. Evidence of the victim most probably on the last that I have submitted before the court.
Hmm?
Evidence of the victim.
Yes.
It was recorded on 15th June. Because they had love affairs, yes, in para 5 you will also will find. I have maintained love affairs with the accuser in the year 2025 in Children's Day. I went to the school day after, I also went to the house of the with scooty. Only hurdle is that she is below 18. Otherwise voluntarily she went with the accused. In a statement under 164 step, is it? Yes, is the evidence. Same facts here stated. In an extra 5 page payment. And page 24, last portion, you'll also find.
Hmm?
A case did, page 24, last portion. A case did not force me in any way. My parents induced me to say that a case forced me, but it did not force me. I myself.
Page 24?
Page 24 of the petition. That
Page
is the-
20,
That's the 183 statement,
What
Hmm.
it is, statement?
last portion. So there was no force, as he voluntarily went,
Induced-
fill up with it.
How old is he?
She is in the powers of measure, now she is 17, 16 plus at that time. Because as per her evidence, she was born in 16 to 2009,
And date of occurrence is 14/11/25.
25,
16 to
2009.
2009 date of birth.
Yes.
She is below 18, exactly.
Hmm. Yes,
So admittedly, she is a minor.
she's a minor, but voluntary and this kind of things.
And already she has
All
been
these statements are there, statements are recorded,
She has been examined. Also.
examined, so I mean, let them face the trial. What is your submission?
Lordship, admittedly, she is a minor, but she has also admitted that she has voluntarily
Mm.
adopted the kid.
Anything, Lordship, he will appear regularly before the
there
trial.
is- Heard Mr. D.K. Talukdar. The learned, it's a D. Talukdar, the learned, D.J. Talukdar, the learned senior counsel, assisted by K. Mohammed. The learned counsel, appearing for the accused applicants. Accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. This is an application in the section 483 of BNSS 2023, praying for grant of bail to the accused applicant in connection with special session special in bracket POCSO case number 26/2026 arising out of Godso police case number 3316/2025 under section 137 bracket 2, BNS, read with section 6 of the POCSO Act 2012. What is the stage now in trial?
Evidence,
Now,
evidence,
evidence
state.
is there.
Hmm?
Only
Evidence.
two
state.
witnesses examined.
Hmm? Two
Witnesses
witnesses examined. Where victim and
Victim and her informant.
informant. Okay.
Only victim, not something.
Hmm?
Informant is yet to be examined. Only the victim is.
Only the victim.
Only the.
Hmm.
Because he is PW1.
The brief facts of the case that on 16/11/2025, the informant filed an FIR before Gorchuk, before Gorchuk police station, alleging inter alia that on 14/11/2025 at about 11 a.m., one unknown person enticed away her 16 years old daughter from Brahmaputra Academy School area. And after area full stop. After communicating with daughter, the informant came to know that the daughter would come back on 15/11/2025 as the parents of the boy did not allow her to come back, and as the night has already fallen by then. It was stated that when she was when she contacted her daughter again, she came to know that boy did not allow her to come back, and while she was the talking with the girl, her phone was snatched away by the accused person, and the same was forcibly switched off. On receipt of the FIR, police registered Gorsok police station case. Registered the Gorsok police station case number 316/2025 under the aforementioned sections. Mr. Talukdar, the learned counsel, appearing for the accused applicants. Accused applicant submits that the alleged victim girl and the accused were in a love relationship, and the girl had voluntarily eloped with the accused applicant, and thereafter they went to Secunderabad, and after staying there for few days, they came back to they're from Guwahati, right? They came back to Guwahati. Came back to Guwahati. The learned counsel further submits that there is no enticement in the instant case, as both were in a love relationship. Full stop. He further submits that the statement under section 183, as well as the deposition before the trial court, reveal that the girl has voluntarily went with the accused applicant without any enticement or force by the accused applicant. He submits that the accused applicant is already behind the bars for 164 days and further custodial detention in the instant case may not be required, taking into account of the fact that the victim girl is already deposed and trial is going on. This year in the instant case has been received and the same is perused. Mr. B. Sharma, the learned APP. What will be your submission, Sharma? Learned APP.
Also, she's a minor.
Learned
And,
APP
consent
submits that admittedly the girl is a minor, and therefore an offense under the POCSO Act has been committed by the accused applicant, and therefore he opposes the bail the prayer of bail. MS P. Parasar, the learned amicus curiae area, appearing for respondent number 2, submits that the girl is a minor, though she has deposed that she has gone voluntarily. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties, as well as peruse the materials brought before this court in brought before this court in the TCR. Full stop. After taking into account the materials available in the TCR, as well as the fact that the victim has already deposed, victim has already deposed before the trial court. This court is of the considered opinion that at this stage the accused applicant, who has already spent 164 days behind the bars, can be granted bail. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of bail bond of rupees 30,000 with a security of like nature to the satisfaction of the to the satisfaction of the additional session judge come special in bracket FOXO, Kamrup Metro at Guwahati. Guwahati subject to the condition that accused applicant shall cooperate with that, cooperate in the trial and appear before the trial court as and when required. It is also directed that the accused applicant shall not try to influence or influence any of the witnesses that may be involved in the instant case. In view of in terms of the aforesaid directions, the instant bail application is disposed of as allowed.
Item 6. May it please your lordship. Charge sheeted case, your lordship. The petitioner is behind the bar since 13/11/2025. The evidence of victim.
Respondent number 2, anybody is appearing?
Lordship,
Amicus
last
curiae was
occasion, amicus was appointed. Lordship.
But
He there.
amicus is not there. PCR is there, but amicus is not there.
Otherwise also, Lordship, this is not a fit case, Lordship.
Hmm?
This is not a fit case for bail, Lordship.
The FIR and from the statement I have annexed, there is no allegation of FOXO, your lordship, against the instant petitioner accused. And the lordship, statement of victim already recorded. Evidence, deposition of victim was given before the court after submitting FIR, charge sheet. But I could not get that copy. There also, the petitioner was not, is not implicated.
We will kindly peruse the medical report as well.
Heard Mr. P. Das, the learned counsel appearing for the accused applicant. Also heard Mr. D. Sharma, the learned APP for the state. Though MSPT MS Priti Das has been engaged, has been appointed as amicus curiae to represent the respondent number 2. Respondent number 2, C, remains absent today when the matter was taken. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Board of BPS case number 40/2025 under section 17(2) stroke 127(2) of BNSS 2023, read with section 6 of the POCSO Act, POCSO Act 2012, read with section 3 in (5) Roman 5 of the Scheduled Caste and Scheduled Tribes in Prevention of Atrocities complete Act 1989. The gist of the case is that on 4/11/2025, one Ram Narayan Ram lodged an FIR before the officer in charge, Bordobi Police Station, Interior, alleging that his daughter Srimati XX is a student of class 7 at Bapuji ME Hindi School, located near Bahadur Gate, Chariali. Full stop. Since right semicolon, that since 3/11/2025, after leaving for school, she has been missing. That after a search at around 5:16 p.m. One e-rickshaw driver, namely Vishnu Tati, informed that the minor daughter of the informant was seen at Chariali TE Road near her school. Semicolon, that immediately the informant along with others went to the above mentioned location, and they found the informant's daughter in an injured condition, wearing torn clothes. That on inquiry, she revealed that after the school was over, she visited Mokuli Hospital situated near her school for checkup regarding her cough and fever. And while returning from Mokuli Hospital, a group of 3 persons forcibly gagged her by putting a cloth in her mouth and dragged her into nearby garden and committed illicit acts with her. Full stop. On receipt of the FIR, the police registered Bordobi Police Station case number 40/2025 under the aforementioned sections. Next para, the accused applicant was arrested on 13/11/2025, and since then he is behind the bars. The police submitted a charge sheet on 31/12/2025, and the matter is pending before the trial court at this stage. The learned counsel appearing for the accused applicant submits that how many days?
243 days.
Submits that the accused applicant is behind the bars for more than 220 days, 20 days, and the victim girl has victim girl has already deposed before the trial court. Therefore, further custodial detention of the accused applicant may not be required in the instant case. Next para. Mr. B. Sharma, the learned APP, on the other hand, opposes the bail application, opposes the prayer of bail by submitting that there are sufficient incriminating materials against the accused, against the accused applicant, and the girl has been, and the minor girl had been forcefully forcefully taken to a nearby bush by the accused applicant, along with others, and committed rape on her. He submits that medical report also supports the case of the prosecution. Full stop.
There are some vital witness left to be
Hmm?
examined. There are some vital witness left to be examined, Lordship.
He further submits that there are several vital witnesses are yet to be examined in the instant case. Therefore, he opposes the bail of the accused applicant. Next paragraph. A TCR in the instant case has been received and the same is perused. After hearing the submissions made by the learned counsel preparing for the respective parties and taking into account the materials available in the TCR, this court is not compliant to grant bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
When CD not received, Lordship.
CD is awaited, later matter will be listed after a week.
Charge sheet submitted, Lordship.
Charge sheet submitted, you go there and approach the trial court. Heard Mr. S.S.A. Rahman, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned
I am
APP.
Triple S Rahman.
Huh?
Triple S Rahman, I am.
Sorry?
I am Triple S Rahman, my lord.
S.
Yes,
S.
yes, I have written triple S. I'm aware of this. You were an old, I mean, you were a senior person in this. I mean, probably we joined at the same time. So I know you very well. Triple S Rahman, yes. Mr. B. Sharma, the learned APP for the state. Then you are appearing. Mr. H. Also heard Mr. H. Rahman, the learned counsel for the informant respondent number 2. Number 2, the learned APP submits that charge sheet in the instant case has already been submitted. By search sheet number
16/26 dated 31/5/26.
26. In view of the filing of the charge sheet, Mr. Rahman submits that he should be given liberty to approach the trial court for appropriate relief. Taking into account the aforesaid submissions and in view of the submission of the charge sheet, the instant bail application is disposed of with the liberty to the accused applicant to approach the trial court for appropriate relief.
Level, Lordship, CD was called for, it has not been received.
CD not received.
CD not received.
Worship, in this case, I am appearing for the informant. Worship. Yesterday, Worship, I filed no color, no Worship.
Okay, heard Mr. S.C.
My
Biswas.
lord, in this case, my lord, I'm going to predict that I am owner of the hospital, hotel, and I stay at Manipur. I am a contractor, my lord, but hotel is running in my name, my lord, and it is being run by manager. There is allegation of sexual harassment to a minor girl. And my lord, in this case, my lord, I have no knowledge. I stay in Manipur, and my lord, it is being run by manager. He is
Yeah,
being
correct.
arrested.
But like if you are opening a hotel, homestay, whatever, you are responsible. You cannot deny responsibilities.
My lord, one thing, my lord, with all apology,
you
my lord,
cannot- you
suppose
cannot-
for this type, for the argument's sake, my
No,
lord,
anyways, like I mean, CD is not there.
for
The CD has to be
sake,
there.
if hotel, Radisson Blu is a hotel based in foreign country, Belgium.
See,
headquarters. If
see,
anything happens.
don't
can
give,
we- can we wrong thing?
Mr. Biswas,
Yes.
don't give those kind of explanations because those explanations and those reasons are very much well known to this court also. That if Holiday Inn, if Mr. Trump, Donald Trump is the owner of a chain of hotel and
Yes.
he's the president of India, something happens there and Trump will not be responsible.
responsible.
That we are aware of this. But still, but that analogy may not be applicable in your case.
Not in the paper.
That-
He's
that-
paying- He's the income tax associate.
Correct. So you should be.
What, the administration
Yeah,
is not in his
I mean,
hand.
you are not the owner of a five-star holiday chain. You are owner of a hotel, a small hotel you are owning,
Not
and
exactly small.
and like whatever. I mean, like if something is happening there, I mean, you'll have to be aware of, but anyways, like, I mean, those comments are out of the records.
Yes, yes.
What I'm saying is that the CD is not received. Let the CD come, then we'll examine.
But I am behind the bar.
Okay. Let the CD come, then we'll examine, because without the CD, how it will be there?
May I pray for a short break? ma'am?
Mr. S.C. Biswas, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned KPP for the state, as well as Mr. B. Chaudhary, the learned counsel, appearing for the informant. Respondent number 2. CD in the instant case is yet to be received. Let the matter be listed in the next week.
24th.
Mr. Biswas, we are posting it in the next week.
Next
24th.
you will kindly
So
put-
now don't ask me ki like,
Date, man, specific date, man.
post it tomorrow.
Specific date. Let it be 22nd, my lord.
24th, Lord, so already lot many cases. are-
23rd. No, sorry.
23rd.
23rd, yes. 23rd.
23rd.
Let it be listed on 23rd.
My dear Lordship, I am appealing for the detained accused. Who is
TCR has
here
come.
since
Yes,
18/10/2024.
18,
18/10/2024.
yes.
More than 20 months elapsed. More than 20 months.
20 months lapse.
More
Okay.
than- yes.
20 months you are behind the bars.
behind the bar.
Yes.
Your Lordship, the case being that two persons,
Hmm.
as per the FIR, but by the STF, one inspector, Prabhakar Singh, he got information that some NDPS articles is to be dealt at Galubari. Accordingly, he along with his team on 17/10 went there at 7:30 PM. But again, reaching there, he did not find anything and got some security information that now dealing is to be done at the Chandmari near flyover bridge. So along with his team, he came back. Then thereafter at 10:44 PM, he saw that two persons are coming with the scooty. And on the footmate of the scooty, one bag he found. And he suspected that after weighing 691 grams of heroin, suspected heroin was recovered, wherein your Lordship will find no local witness is there. Kamalpur, Baihata, etc. is to witness your Lordship. Whereas Chandmari, there are so many residents, hotels, none of the local witnesses there. And not informed even to the Chandmari police, only his staffs are there. And in this case, Lordship, the charge was submitted, charge was framed, your Lordship. I have mentioned page number 7 on 6/6/2025 by the special judge. Page number 7, paragraph number 10, Lordship.
Hmm.
6/6/2025.
Hmm.
And before 19/12/2025, not even a single witness. Only on 19/12/2025, one witness was examined.
Hmm.
Whereas, as per the charge sheet, there are as many as 11 number of witnesses, Lordship. And the record has been called for. And there also, the expert who was examined, there is also variance of the weight. What she weighed, what it was sent as per the IO. And your Lordship, I am a local boy. And as per the charge sheet, there is mentioned that there is no provisional or permanent any criminal record against me. In the charge sheet, Lordship, it is there. And what I do, it is also mentioned that I do a tattoo business. A boy of 35 years, he is having movable and immovable property in the Chandmari area behind the Gauhati college.
So what is your ground?
Ground, Lordship, that more than 20 months past. Lordship, he is a local man. Your Lordship, he will not jump. Any condition may be imposed. This honorable court has got the special inherent power to grant bail.
Here it is charge sheet submitted on 10/4/25
No,
and charge framed on 6/6/25
yes. And thereafter,
and 691 grams heroin recovered from their possession. Lordship.
no, not from position, not even a single paisa physical position, not any article.
It's a matter of
Only-
commercial quantity, Lordship, it is commercial quantity. So some witnesses, PW should be examined, Lordship, at this stage. Only one PW should examine. Is a forensic expert.
Yes, and there is also not a specific. So your Lordship has got the inherent power. I am a local boy. Any condition, he imposed, your Lordship. He is a boy of 35 years. And your Lordship, in the bail order 19/12/2025, kindly be seen. I have annexed to page 15. Kindly it should be perused. That the alleged scooter also belonged to one Tapan Deka, who happens to be the brother of co-accused Manoj Deka.
So what happens with that?
And
How does it help your case?
Alan,
How does it helps your case? How does it help your case?
no, your Lordship, I am also not the owner or.
No,
no-
correct. I mean, you may be riding somebody else's vehicle and like you may be doing something illegal things using somebody else's vehicle. How
No.
does it help your case?
Lordship, though no criminal antecedent and no local witness is there in this case, your Lordship. Nothing. From the charge sheet, your Lordship, you will find that all are outsider. All the local witnesses, none of the local witnesses there. All are our two witnesses and all are outsiders. No Chandmari police had been informed. None of the local police, whereas only 1.5 kilometer, less than half kilometer, 1.5 kilometer is at Chandmari PS. And same thing in the case record has been repeated by the IO. Same thing. Have there been any criminal record, any of this sort?
The police, Mr. Singh, the police has not come from Maharashtra or West Bengal. The police followed them from Jalukbari to Chanmari, getting information that the deal will be done in Chanmari. So they have been already following him. So now you can't say that like they have come from, a different place and like that local police should have been informed. They're the same police.
At least
Jalukbari police station.
over phone, your Lordship, nowadays.
Is there any statutory provision for that?
Yes.
That local police has to be informed
There is
when
local
while from the same city, a police team is following somebody and they suddenly get to know,
Lordship,
is there any
local-
statutory provision?
Actually, local police is informed, your Lordship. Local.
They are local police only, Jalukbari police station.
Ye Chandmari, your Lordship.
They have been following from Jalukbari to Chanmari.
No, from this my police station STM, they went there. Thereafter they came here. There was sufficient time to inform about police law. And more than 20 months passed in this case. And your Lordship has a special power to grant, and your Lordship can impose.
Section
any con-
37 is
Yes.
there in NDPS case that I'll have to be convinced that, I mean, this person can be released.
Yes, Lordship, I am giving one judgment
Yes.
of the Bombay High.
What does it say?
everything has been discussed. Section 36C also.
Are you arguing on section 36?
37. 37, where 36 also has been discussed.
No, 36, are you arguing on 36? Then we'll have to postpone it for some time. Because as far the issue of 36 is concerned, that has been referred to a division bench. If you are arguing on section 36, arrest memo contains witnesses or not?
Yes.
Hmm? Are you arguing on that issue?
No, 36, that
Not arguing on it.
this Honorable High Court and the Supreme Court are immune under section 37 as it is in the case of the special judge. Last paragraph 26, and before that everything in details has been discussed by his lordship. There is no bar to grant bail. Nothing of the sort in under the NDPS Act. There was also case under section 21, 29, as in my case.
But Supreme Court says otherwise. Supreme Court says that section 37 of NDPS Act is squarely applicable to High Court also. But in this judgment, the judgment that you have given me,
In other judgments also I have.
No, no,
I have
no.
similar, Your Lordship, but only one I have earlier, when the.
no, this,
NDPS
no,
Act-
see, Mr. Singh, this is the judgment you have submitted. Here it is stated that let NDPS Act 37, it mentions about the term court, and court is not the High Court, the other courts.
Yes.
But
yes,
that
yes.
is not the view of the Supreme Court. That is not the view of the Supreme Court. Supreme Court has, handled many of the cases wherein section 37 of NDPS Act is applicable, and wherein the High Courts have rejected the bails on the ground of section 37. The
Yes.
Supreme Court did not say anything about this. Supreme Court did not say that High Court is not, that section
some other
37
date
NDPS is
fixed.
not applicable to the High Court.
Some other date be fixed, Your Lordship. So far, the rulings I have got, Lordship, I have got this.
If you want to say that section 37 of the NDPS Act, that rigors of section 37 is not required to be, complied with by the High Court, then it's a different thing. But
Yes.
where is that law?
In this judgment itself.
In this judgment says, this is,
I am showing Your Lordship. 36
36 of what?
A of the NDPS Act.
NDPS Act. 36A.
Just a minute. 36, it will be 3, Lordship. 36 A,
36A says about what?
3.
36A3.
A3.
Hmm.
Nothing contained in this section shall be deemed to affect the special powers of High Court regarding bail under section 439 of the Code of Criminal Procedure, and the High Court may exercise such powers, including the power under clause G of subsection 1 of that section, as if the refer to magistrate in that section included also a reference to a special court constituted under section 36.
So High Court, it says that High Court shall have the power of the special courts also.
No, 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 no.
Then
Only earlier it was.
nothing
magistrate.
contained, wait, nothing contained in this section shall be deemed to affect the special powers of the High Court regarding bail under section 439 of the Code of Criminal Procedure. There is no doubt about this procedure, and the High Court may exercise such powers, including power under clause B of section 1 of that section. So clause B of section 1 of section 439 of CRPC, as if the reference to magistrate in that section included also reference to a special code considered under section 36. But where does it say that NDPS 37 is not applicable?
It shows, Lordship, that bar is only in the case of magistrate and the special judge.
No, no, no.
And the Honorable High Court and the Supreme Court.
No, let us come to section 37. Let us read section 37.
Yes, Lordship, notwithstanding.
Offenses to be cognizable, non-cognizable, notwithstanding anything contained in Code of Criminal Procedure Code 1973. So whatever is there is there. Every offense punishable under this act shall be cognizable. No person accused of an offense punishable for so and so or so and so for offenses involving commercial quantities shall be released. Mr. Singh.
Lordship, it is only my distribution.
No. I mean, we are not agreeable to your what are the views.
Another date we fix so that.
Why should I give you another date?
I will.
No, you have come up with some submission which is not at all acceptable.
Lordship, that if I find something that will be also one.
See, it is the language is very clear that notwithstanding please, Mrs. Singh, please listen. It says notwithstanding anything contained in section CRPC 1973.
Only for the trial courts, Lordship. My respective submission, it is binding only for the trial courts.
Where does it say so?
Yeah, in the
It says about bail shall be released on bail
by the trial courts, Lordship.
on his bond unless the public prosecutor so and so.
Of that court, a special public.
No, it doesn't say so.
Your Lordship, my respective submission.
Section 37, section 37 is only confined to the special court. It doesn't say so.
Yes, sir. Lordship, one date be given so that I will satisfy bringing the apex courts of orders and so many things.
Okay. On the prayer of Mr. You have Mr. R.S. Singh.
RP
Singh, the learned counsel, appearing for the accused applicant. Let the matter be listed.
On 30 July, Lordship.
On 30th July. You're from outside?
No, from here itself, Lordship.
Okay.
Because I have got some.
Okay, on 30th of July. You want to take this case, take back this case, please take it back this case and bring it on 30th.
That's for time being.
Huh?
Senior counsel A.S. Sodhuri minor is leading court number 6 minor.
Very please, your lordship. So we have taken steps on the respond number 2.
Lordship, we have received the instruction, service is complete, Lordship.
Service is complete when?
We have received it yesterday, Lordship. On 14, today itself, Lordship, we have received.
No, when is there any information when it was notice was served?
That, Lordship, is not clear from here. Date is not there, Lordship.
Right, that is the important thing. If it is served yesterday, how this informant will manage
10/7, Lordship.
10/7,
10/7, yes, 10/7.
Today 14.
10/7, so we'll wait for some time. Heard Mr. N. Hassan, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APE for the state. Mr. B. Sharma, the learned APP submits that, that notice, service of notice on respondent number 2 has been received. And the same is served on the respondent number 2 on
10/7.
10/7/2026. However, none appeared for respondent number 2, taking into account of the fact that the notice was served only on 10/7/2026. 26, that the matter be listed. Let the matter be listed on
On 20th.
on 28th July.
See, in this case, we are seeking default. We are seeking default bill notes.
How many days?
Statutory period is over, but so some on other point, Lordship, we are seeking.
Statutory period is over.
But charge sheet was laid after Lordship, statutory period is over. That one judgment.
That you have not come in due time.
There is some delay in approaching, but would it be on 20th, Lordship? Then
What happens then if charge sheet is filed after the mandatory period?
Then also they will be entitled for.
He'll be entitled to bail.
We will see to it, Lordship.
Hmm?
Let us wait for the next date, Lordship. On that day,
But if it is default, whether he is there or not there doesn't make any difference.
then Lordship will have to go to the record again, Lordship will have to verify
Hmm?
that claim.
That
Even then-
record has to be seen. I mean,
Yes.
he'll have to verify it, you verify it.
Even then, Lordship, the respondent has a right, Lordship, to object to the bill.
No, if default is there, I mean, what objection he will do? This is statutory, provision.
Lordship.
What objection he will do?
If they,
Now, in case of the merit, that is fine, but in case of default bail, that is a statutory provision.
yes, that is
Hmm?
correct, Lordship.
And like, if he is eligible to bail, there is no right to keep him inside the
Yes.
jail.
That is there, Lordship. That is there.
actual Lordship, we are seeking short date, Lordship. So that
Okay. Then 21st we'll keep it, 21st. 21st we'll see.
oblige.
Regular bail application. FIR is page 18, Lordship, Banagular Patro.
Hmm?
Page 18,
Is 18. FIR.
FIR.
Yes. What is the offense?
Catalog
Allegation?
PCR.
Hmm?
But basically in the FIR, allegation against the driver, Lordship. But the petitioner ONDR, as informed by the helper of the vehicle, to
No, but what is the allegation?
allegation.
Transportation of cattle,
transportation
illegal
of
transportation of
cattle.
cattle, Lordship.
The puncture of the tire, there is the petition number 3 is the co-accused Mohibul and is the younger brother, Lordship.
Alam Batsa is who? Alam Batsa and 3
Alam
others?
Baksha is the owner of a shop.
Hmm?
where Alam Baksha has a shop for repairing tire, Lordship.
Shop for
Repairing tire, Lordship.
repairing tire.
Tire.
Yes.
So, petition number 3 is the elder brother of Mahabul Ali, who is the helper of the seized vehicle, Lordship. And the petition number 3,
Alam Batsa is the owner of a shop. Then what has happened? How he is linked?
Your Honor, the petition number 3 informed the petition number 1
Hmm.
for repairing
Petitioner number 3 is who?
co-accused, elder brother of co-accused Mahabul Ali.
So how he is linked?
Thereafter, the informed the petition number 1 and along with the petition number 1,
I'm not understanding anything what you are saying. I am asking you a simple question, how they are implicated, how they are involved.
Your Honor, they went their place of occurrence as informed by the Mahabul Ali for repairing tire, Lordship. Then
So
fi-
repairing tire and smuggling of cattle, how does it link? You explain me properly.
Your Honor,
If you cannot tell me the facts also, how how you will argue a case?
I can understood that.
If you cannot tell me the facts, how you are going to argue a case? You tell me the facts. What
Fact
has
is
happened?
that, Your Honor, as per the information, the petitioners were on the place of occurrence. Thereafter, the local public on
What place of occurrence? What happened in the place?
kindly see page 18, Your Honor.
You read the affair, read the affair.
অনুবাদপূর্বক বিনীত নিবেদন এই যে
Read properly. Read properly so that I can understand.
সম্মানপূর্বক বিনীত নিবেদন এই যে দোয়া ইংরাজি 20/5/2006 তারিখে
Read the
রাতে-
translated version. If you have done the translation properly.
রাতি অনুমান 12 মান বজাত
You read the translated version.
With due respect, I beg to state that on 25/2026 at around 12 midnight, I came to know from a secret information that a Max pickup vehicle bearing registration number so and so with stolen cattle will transfer from Dharampur towards Lakhimpur. After knowing, I immediately informed to the OC of Lakhimpur PS over phone, and as per his instructions, I along with staff proceeded towards Dharampur Bazaar and laid an ambush to Dharampur Bazaar to intercept the said vehicle. At night, about 1:30 AM, the said vehicle loaded with cattle approached at high.
Did you file any bail earlier?
No, Lordship.
Hmm?
No. Lordship, 2 days, 54 days behind the bar.
4 persons were arrested.
They were,
Hmm?
when they are in a four-wheeler vehicle,
The other persons were given bail over.
No, people,
Who-
yeah, here 4
and
persons.
as per instruction, Ruhul Amin and Ilog Marak were allowed to go on well by the learned court of district and session judge Gwalpara yesterday. Lordship.
As per the statement of the accused petitioner also.
54 days,
Yes.
60 days
54 days.
mandatory.
Mandatory 60 days. Lordship.
The one person which was, he has submitted the granted bail, Tilok P. Marak. He has
And-
instructed to carry the cattle to these petitioners. Also. And as per their statement, another person was there, the Rasul Hawk is. He was the,
Ruhul Amin.
he is the behind the main scene, Lordship, who stolen the kettles and from the Lakhimpur area and illegally transported the kettles to the other states, Lordship. It was Meghalaya also.
They are not involved in this case, but the public put them on suspicion as they are out if and after assaulting handed over the police.
Please let me read. Hmm? You could not explain anything to me. I could not understand anything to you. I understood anything from you. Now let me read at least. Right, heard, Mr. What is your name?
A is Ahmed.
Huh?
A is Ahmed.
A. H. Ahmed, the learned counsel appearing for the accused applicants. Also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 483 of BNSS. BNSS praying for, BNSS 2023, praying for bail to the accused applicants in connection with Lakipur PS case number 79/2026. 26 under section 132/325/313(1)/317(2)/3 of BNS read with section 11 in bracket 1 bracket small a stroke 11 bracket 1 in bracket 2 bracket small d of the Prevention of Cruelty to the Animals Act 1960, read with section 1, read with section 13(1) of the Assam Cattle Preservation Act 2021. Full stop. The gist of the case is that on receipt of a secret information on 21/5/2026, the police party tried to intercept the vehicle, a vehicle which was carrying cattle at Dhamur Bazaar, semicolon, that the vehicle which was coming in high speed fled away. However, since the tire of the vehicle was punctured, the vehicle had to stop after certain distance, and the people inside the vehicle along with the cattle were recovered by police. The police found that two cattle have already died due to suffocation inside the vehicle, and they have been brutally tied by the people people traveling in the vehicle. The police registered Lakipur PS case number 79/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicants were arrested on 21/5/2026, and they have already spent 54 days behind the bars. He further submits that the accused applicants have bought both those cattle in a legal manner and transporting them in with valid documents. Full stop. Mr. Goswami, 54 days.
Yes.
I don't want to retain them anymore. Mr. And therefore he submits that the accused applicants should be granted bail at this stage. Full stop. Mr. D.P. Goswami, the learned APP, has produced the case diary before this court. After perusal of the case diary and taking into the fact that the accused applicants have already spent 54 days behind the bars, this court is of the considered opinion that the accused applicants should be granted bail at this stage. Accordingly, the accused applicants, accordingly it is directed that the accused applicants shall be released forthwith from jail on furnishing of bail bond of rupees 30,000 each, with a security of like nature, subject to the satisfaction of which court?
CGM Goalpara.
CGM to the satisfaction of the CGM Goalpara, subject to the following conditions. But the accused applicants, number one, accused applicants shall, subject to the condition that accused applicants shall cooperate with the investigation and shall make themselves available as and when called for by the investigating officer. In terms of the aforesaid direction, the instant bail application is disposed of. Much. Okay, come reading the facts, then it becomes easier for the court.
We have not received the case in 16 also.
Is they not received?
Yes, Lordship.
May it please your lordship, it is a 90 days study period lordship.
Hmm.
And as on today, 81 days behind our
Hmm?
lordship, 81 days behind our lordship.
So we'll put it on the next week.
Lordship.
Case that is yet to be received, let the matter be listed. Case that is yet to be received, let the matter be listed in the next week.
Date may be fixed lordship, date may be fixed lordship.
Let the matter be fixed on 20th,
20,
2020.
20 lordship.
Okay, happy?
Oh, lordship.
20th we'll see.
17.
We have not received the case there.
Already 49 days behind,
49 days.
49 days, Your Lord.
So wait for some time. Case that is yet to be received, let the matter be listed on
21st.
22nd or
22nd.
It may also we have not received the case there.
May please, Lordship, here as a submission, Madam. But you know, they are the drivers and handymen in which vehicle, Madam, where cattles were being carried, Madam. Now, Madam, the owner of the cattles were granted period bail. I've annexed the order. Owner of the vehicle has been granted period bail. Even the cattles were given Jimma to the owners. I've annexed the order, Madam. May I take?
We'll give a short date.
Lordship, may kindly.
No, we'll give a short date, Mr.
Everyone-
Palvi. We'll give a short date. We'll give a short date.
But everyone got bail, Madam. Even the cattles were given Jimma to the owner of the cattles, Madam. I've annexed the order. So these are not stolen cattles, Madam. The order,
Then
Madam.
those kettles were for what purpose
Madam,
and
wait,
for
yes.
where it was going,
Yes, Madam.
from where it was brought.
Yes, page
Huh?
38, Madam.
Then tell me, Mr. Palvi, who for
Yes, Madam, it was.
what was the purpose for
No,
the
we don't know,
kettles?
Madam. The owner of the cattle's, Madam, he has been granted pre-arrest bail. The owner of the vehicle has been.
Where are the bail orders?
Orders, Madam, bail orders of the, Madam. It starts from, Madam, page 31, Madam.
Yes.
Alia, but not 30, yes, 31, Madam. Ali Akbar is the owner of the cattles.
Hanif Ali is who?
Hanif
Ali-
Ali is the owner of the vehicle.
Owner of the vehicle.
Yeah. And, Madam, the
And this person, Ali Akbar is the
owner of the cattles.
owner of the cattle. So
Owner.
all of them have been given bail,
Pre-arrest bail, Madam.
PRS bail.
And the Jimma of the vehicle, of the Ali Akbar has been granted Jimma of those.
Mr. Goswami, I mean, they have been given bail, then what is the, I mean, what remains in this?
The driver and the handyman. Madam.
Driver and the
And
handyman.
36, Madam, is the order of the Jimma or Jimma order of the cattle.
Okay, then you write, heard Mr. S.M. Abdullah P, the learned counsel, appearing for the accused applicants. Accused applicants also heard Mr. D.P. Goswami, the learned APP for the state. Reason application under section 483 of BNSS 2023, praying for granting bail to the accused applicants in connection with Hajo PS case number 223/2026 under sections 303(2)/3(5) BNS read with section 13(1) of Assam Cattle Prohibition Act 2021, read with section 1, section 11 in bracket 1 bracket small d of Prevention of Cruelty to Animals Act 1960 and 60, read with section 125 of the Central Motor Vehicle Rules 1989. The case relates to
Page 10, Madam.
mm,
Page 10.
the case relates to recovery of 11 numbers of cattles from the vehicle driven by the accused number 1 and the accused applicant number 1, wherein the accused applicant number 2 was the handyman. Mr. The learned counsel appearing for the accused applicant submits that the owner of the vehicle, Hanif Ali.
Hanif Ali.
Owner of the vehicle, namely Hanif Ali, has already been granted bail by a coordinate bench of this court, vide his order dated 12/6/2026. And similarly, the owner of the cattles, namely Ali Akbar, has also been granted bail, granted pre-arrest bail. Pre-arrest bail, both earlier one was a pre-arrest bail on 11/6/2026 and 2026 full stop. The Jimma of the vehicle, Jimma of the cattle was also granted to the owner on 12/6/2026 by the learned JMFC Hajo. Full stop. He submits that in view of grant of pre-arrest bail as well as pre-arrest bail to the owner of the cattle and the vehicle as well as Jimma, as well as the order of Jimma given in favor of the owner of the cattle. This is a fit case wherein the accused applicants who are only the driver and handyman of the vehicle should be released on bail. Full stop. Taking into taking into account the submissions made by the learned counsel appearing for the accused applicant, this court is of the opinion that the accused applicant should be granted bail. Accordingly, it is directed that the accused applicants shall be released forthwith from jail on furnishing of bail bond of ₹20,000 with surety of like nature to the satisfaction of the JMFC Hajo, subject to the condition that the accused applicants shall cooperate with the investigation and make themselves available as and when called for by the investigating officer. In terms of the aforesaid direction, the instant bail application is disposed of.
Which is 19 and 45 arising out of the same FI Lordship. CD has not been received and
It is not received.
we have received the communication from the IO Lordship. He has sought for 1 week's time to produce the case.
Can it be on Monday, my lord? From Panbaza itself.
Hmm?
Next week, Monday, my lord.
Okay, CD in the instant case is yet to be received. Let the matter be listed on
20th.
22nd.
Obliged. Here also Lordship, CD has not been received.
Lordship, I am behind the bar for 75 days, Lordship. The only
90 days.
75 days.
90 days of-
of- They have registered it as a 307 IPC, Lordship. I have.
So we'll wait for some time, Mr. Pujara.
Lordship,
Let,
it was second date of CD.
Huh?
Second date of CD, Lordship. On
Okay.
7th also it was picked on CD, Lordship.
correct. I mean, we wait for some time because
Lordship,
let the
if
CD
possible,
come.
Lordship, I may be released on interim.
I know
bail, Lordship.
without the CD, it will be difficult to adjudicate this matter.
Let it be on Friday, Lordship, next Friday.
No, Friday, no. CD is
It
yet
is
to be,
Morigaon, from Morigaon.
CD is yet to be received. Let the matter be listed on 22nd.
22nd.
22nd. May it be 21, Lordship. 22nd, I may have.
21. 21.
Lordship. 21.
May I please your lordship?
Yes.
Application under section 483, my lord, offenses under section, my lord, immoral trafficking prohibition. And under section, my lord, 143 of the BNS. This lady, my lord, she was arrested on, my lord, 16/6/26.
16?
16/6.
16/6.
Yes.
2026.
29 days in custody.
29 days. Offense is illegal trafficking, I mean immoral trafficking.
Yes.
And human trafficking also. Lordship. 143 is also there.
Hmm?
143 of
143
Hmm.
BNS is also there. No? Triple
143,
the
61.
Immoral Traffic Prevention Act. A raid was conducted in the hotel, my lord. And some, my lord, 17 boys and girls, they were found in the, 7 or 8 boys were found.
Several witnesses have been examined means what?
Lordship.
I mean,
All the statement of the, my lord, those victim girls, it has reflected in the affair itself, my lord.
no,
That's it.
I mean, the trial is going on.
No, my lord.
No. Under
Then
investigation,
how come the statement has come that several witnesses have been examined?
witnesses 161 Lordship.
They are 160.
161 cannot be said they're examined.
Some Lordship 183 also has been recorded. Some witnesses.
Okay, but examine what
Yes,
cannot be used?
Yes.
My only prayer before your lordship, my lord, considering the period of detention, my lord.
29 days only.
My lord, offenses of 60 days, my lord.
Hmm.
No,
And
one
seeing a lady, my lord, a
143
divorcee and has
90
got a
days.
5 years.
90
daughter,
days, 90 days.
143 is 90 days.
143 is 90 days.
That
143 is 90 days.
DNS.
143, my lord. Next part.
Huh?
Whoever commits the offense of trafficking shall be punished with rigorous imprisonment for a term which shall not be less than 7 years, but which may extend to 10 years and shall also be liable to fine.
So,
Next part.
And when the offense involving the trafficking of more than one person, it shall be punishable with rigorous imprisonment for a term which shall not be less than or which may be extend to life.
Yes.
Whether, my lord, the trafficking is there in our affair. I am on that one.
The case that it is there also. FIR it may not be there, but case that it is there also.
Affair it is
you
not.
have received the case there.
Yes.
And my lord, that section 15 and my lord is 14, those has not been complied with, my lord.
Section?
Section 15, my lord, charged without warrant. When they went to the hotel, my lord, as per the subsection 2, my lord, they ought to have taken, my lord, along with the trafficking officer, my lord.
Hmm?
Along with the traffic, before making a charge, under subsection 1, the special police officer or the trafficking police officer, as the case may be, shall call upon 2 or more respectable inhabitants. And out of those, my lord, one must be a woman, my lord. My humble submission, my lord, that was not followed. And my lord, that special officer, my lord, that is also defined as per the section 13, my lord. That there shall be for each area to be specified by the state government in this behalf, a special police officer appointed by or on behalf of the government for dealing with offenses under this act in that area, my lord. And he should not be, my lord, below the rank of a inspector, my lord.
Mr. Sharma, I mean, have you gone through the case there?
Yes.
All these things, I mean, he has
See,
come up.
I will stick to 143 also. Without going into this immoral thing, I will stick to the 143 and I will make my submission also regarding trafficking of women lordship, more than one woman.
No, he's realizing that search was not done.
Yes, that is in respect of lordship immoral trafficking.
Hmm.
If the charges under immoral trafficking are there. But I am stressing my point on 143 of the BNSS lordship. I will point that lordship.
She will kindly come to the affair, my
Okay,
lord.
Okay, we'll take it
Yes.
up after 5
Fine,
minutes.
yes,
fine.
yes.
Affair lordship will find at page 19, my lord.
Yes, Mr. Sharma, now the FIR reveals that all provisions are complied with.
Yes.
From your CD, I mean,
Yes.
his allegation says that SARS was done without warrant, without statutory compliances.
No, no,
That
it's not.
from there, what is there in the CD?
Lordship, it is also reflected in the order that they have annexed.
Hmm.
It, at page 25 also, Lordship.
Page 25.
Yes, they were escorted by it was, the search was under the leadership of Aditya.
Yeah, that was
Reddy,
there.
And there were also female officers were also present there.
There,
So that is there, Lordship. Everything is there.
I am only on my lord independent person, not on the my lord police officer.
Hmm?
I am an independent person, man. Even my lord, the earlier section 100 of the my lord,
Which provision you were reading?
my lord,
I-
section 15, my lord, subsection 2 of my lord, the immoral traffic prevention. And my lord. May I just read it, my lord, slowly? May I read it?
Yes.
Before making a search under subsection 1, the special officer, police officer, or the trafficking police officer, as the case may be,
Trafficking police officer means?
that,
Is
my
it
lord,
defined?
that is also, my lord, another point I wanted to, my lord, submit, my lord. Section 13, my lord. Special police officer and advisory body, that is section 13. There shall be for each area to be specified by the state government in this behalf. A special police officer appointed by or on behalf of that government for dealing with offenses under this act in that area. Whether, my lord, all the police officer has given that power or not, my lord.
But that permission was given by the magistrate, judicial
Yes.
magistrate.
Yes.
No,
Yes.
that is, my lord, if it is in the night time, man.
Yes,
Right
that was there.
Yeah.
43(5) is complied with
Yes,
because that female were there, females were there.
yes. That is complied, my lord.
Now, who is the special police officer?
My lord, that is defined in this, my lord, Immoral Traffic Act, my lord, section 2I. Clause I, my lord. Special police officer means a police officer appointed by or on behalf of the state government to be in charge of police duties within a specified area for the purpose of this act. And my lord, trafficking police officer, he has to be, my lord, appointed by the central government.
But that is different. I mean, the
That is different.
trafficking is the police
Yes,
officer, not there.
So, my lord, we are also not very much clear, my lord, whether this police officer, my lord, he has been appointed as a special police officer or not. And my lord, in our case, my lord, the search and seizures should be made by a rank of, my lord, police official of the rank of inspector, my lord. But in our case, my lord, seizure was made by that, my lord, ASI, Assistant Sub-Inspector.
Where is that?
Is that? First thing, my lord, in our case, my lord, while making the charge, my lord, no independent person was taken. That is, my lord, mandatory provision. In this act also, my lord, rather, in my lord, BNSS also, my lord, section 1034, my lord.
Section 10.
1034, my lord,
Hmm.
of BNSS.
Hmm.
Before making a search under the chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality in which the place to be charged is situated or of any other locality, if no such inhabitant of the same locality is available or is willing to be witness to the charge, to attend and witness the charge and may issue an order in writing to them or any of them so to do. It is, my lord, as good as, my lord, the section 13(2), my lord. 15(2), I am sorry, my lord, 15(2) of the Immoral Traffic Prevention Act.
Hmm. 103, which provision you read?
My lord, subsection 4, my
Subsection?
4.
Arrest memo is there.
Yes, sir, everything.
Where is that?
Arrest
Marked,
memo.
na?
Arrest memo. We have not marked it, Lordship, arrest memo.
Because he is saying that independent witnesses are not there. So we can see from the arrest memo, no, whether independent witnesses are there or not.
We can mark it, Lordship.
Please have a look.
Yes.
Caesar memo contains independent witnesses.
Caesar memo contained independent. That is by my
The-
lord.
Let us see in the arrest memo.
Yes, but that is by rank of my lord ASI, not by inspector.
It was under the leadership of the additional SP. Now, Lordship, additional SP will also make the seizure. That is not necessary, Lordship. It is, this search was conducted under the leadership of the additional SP.
But only thing, my lord, as per this act, my lord, one should be a special police officer. And that is, my lord, defined.
And that may be the reason why this additional
Yes,
SP
yes.
went there. He may
wa-
be the special
Yes, my
officer.
lord, he was informed. He was informed, my lord.
He accompanied. He
Yes,
was in
accompanied-
the
he
search team.
accompanied me. Because they had a secret information, my lord.
Correct. So like additional SP went means that he's a high ranked officer.
Yes,
He,
high rank
I
officer.
mean, he went for the search.
Yes, yes. I am only on that, my lord, the special police officer, my lord,
Lordship, is that-
whether,
Now, see, Mr. Sharma, this special police officer is very categorically stated here. This is a mandate.
yes.
Either if there is any allegation of immoral trafficking or prostitution in a place, then that has to be conducted by
Special.
a special police officer or a trafficking police officer. A trafficking police officer has to be appointed by central government
Central
by notification.
Different issue.
Special office police officer, I mean, usually I don't think traffic police, since state
Yes.
is having the power,
Yes.
state will at least, yeah, I mean, delegate or like appoint somebody as a special police officer. And if that is not done, then there is a violation.
Then
So now you find out whether the additional SP is
Yes,
special
ma'am.
officer or not.
I will have to take their instruction, Lordship.
Hmm?
I will have to take their instruction, Lordship.
We'll have to take the instruction. I'll see whether it is there or not.
It will not be there, Lordship, because that will not be mentioned in the.
See, that will be a crucial aspect because he's arguing that.
Yes.
And the act provides that.
Lordship, there is one more thing, Lordship, two more things, Lordship, to be sure. Lordship, these points, these technical points that they are taking, I'm not opposing that, Lordship, but they cannot take us by surprise, Lordship, each time. They have to specifically mention the grounds that they are urging, so that we can also be prepared, Lordship. Every time, Lordship, a bail petition is filed with no grounds, then now they are taking the technical grounds, Lordship. Where is
Those
the?
are legal grounds.
No, legal grounds, Lordship, but they have to mention it in the petition. At least vividly also, they should mention it in the bail application. They cannot take us by surprise every time, Lordship.
Okay, we'll put it up for some other
Yes,
day.
some other day, Lordship, we'll take it up, or we'll take the instruction on.
My lord,
Uh,
can it be, my lord, the after tomorrow only that instruction is to be taken? Whether he is, my lord,
Okay, heard Mr. B.M. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state on the joint prayer. Now on the prayer of Mr. B. Sharma, let the matter be listed on 16th?
Yes,
16, only you take, see, we have got to know his
Yes, yes.
basic
whether he's.
basic
empowered
legal,
to-
he is empowered to or not,
Yes,
or,
yes.
or find out whether there's independent witnesses were there or not. These are two main grounds he is taking.
Lordship. Lordship.
because for that reason, my lord, some notification has to be there, my lord, that he has been.
And that
appointed.
let him find out, I mean, what is there, এখন দিতে বসেন রে, under prayer of so and so, let the matter be fixed on 16th, huh? 16th.
I'm obliged also.
This case model, that IPL, that 45 days today, my.
Hmm?
That IPL, my lord, that is betting and gambling,
No betting.
betting and gambling.
Hmm.
So, my lord, everything is seized, my lord, assuming a correct, my lord, 45 days. I am only on the count the length of detention, 60 days is the statutory period, my. Your Honor, can I see the
You
FIR?
are 40, you are behind the bars of 45 days.
45 or 44? 44 days. 44. And FIR is page 14. Everything is seized also, my lord. I think, my lord, further custody, I'm only on that, this thing. Now happens, my lord, this type of things nowadays. Page 1.
Mr. Goswami, what is happening to the investigation?
No, if sufficient materials are there against the petitioner also here, also. Like, yes, involving in this type of
Hmm?
illegal business from 2022. He is admitted also, and some from that WhatsApp messages, some along with his some associates, he has transacted huge amounts to that various bank departments. And also, Lordship, some of the co-accused also implicating him. That yes, we are.
All the persons have been
Yes, yes.
arrested.
All the persons were arrested. Lordship.
Arrested. The materials have been seized.
Seized,
Yes,
Lordship.
yes.
And
Mm.
ATM card report, bank statements were already received from the
Statements have been taken.
taken, Lordship.
So what is the requirement now?
Let me some as part of
What is your instruction? Is there any specific instruction?
some Lordship. Some yeah, as per the statements of the objection to the IO Lordship, to analyze the verify collect digital evidence by the accused person. Some digital evidence is yet to be recovered from the arrested accused person. And Lordship, to find a full network behind his large scale illegal betting activity. So like that, various co-associates are there, Lordship. So lots of person yet to be arrested, Lordship. Otherwise, sufficient materials are collected and against this petitioner also.
I am not on materials, but everything seized, madam. My honest friend is careful. I need to always lordship on page 14. Nigunda's aids following articles are recovered and seized under the proposed results. My only question, further custody, whether they can say for what purpose is custody requirement. The rest I leave to your worship.
These two matters are same. This,
Number one is Inamul Haq, is the associates of him.
you are Inamul Haq.
He was engaged to from receipt from customers, money from receipt from the customers, he was engaged by this petitioner. He influenced the customers to engage in the betting, IPL betting.
I feel further custody for the ends of justice. They will.
So you are in custody for how many days? 32 days. Okay, heard Mr. H.R. Chaudhary, the London Senior Counsel, assisted by so-and-so. This is in bail application 1603, 1603-2026. This is an application under section 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with Kolgachia PS case number 54/2026. The people of Kolgachia were supposed to be hardworking people in fields all the time. Now what is happening? They are going to the gambling dance, started organizing gambling. Huh? Huh?
Some access to everywhere is there.
But they are reputed
It's
to
like
be,
tem-
they are,
temptation.
they are reputed to be very hardworking people.
Yes.
They
yes.
do, most of the
But
products
personal knowledge about that, yeah.
come from them. That's what we have also heard, but though no personal knowledge. But now why it's happening that like they started
That I
doing
think
a-
now they have learned the lesson, my lord. I don't think they will go now. Enough
Mhm.
time.
in connection with Kalgasia PS case number 54/2026, registered under section 318 in bracket 4/316 BNS read with section 14 of Assam Game and Betting Act. Full stop. The gist of the fact is that on 13/5/2026, the complainant, namely SI Jitul Das of Kolgasia Police Station, lost an FIR before the Kolgasia Police Station against the accused person, against the accused applicant, alleging that on 31/5/2026 at about 8:30 AM, on receipt of a credible information about illegal betting during the IPL during the Indian Premier League in bracket cricket. Using mobile phone at Kharisala Bazaar area. Semicolon, that no, it was also full stop. It was alleged that acting upon such information, the police team reached the place of the police team proceeded to the place of occurrence and conducted a raid and search upon the house of the accused applicant. The police recovered during the search and raid. The police recovered substantial. Police recovered couple of mobile phones along with debit cards of various banks in the name of different persons. After recovery of those materials, on further information, the police raided another place. Another place at Green Hillside apartment, Bohista, Guwahati, and recovered several debit cards belong to different persons. On receipt of the FIR, the police registered Kolgasia Police Station case number 54/2026 under the aforementioned sections. The accused applicant was arrested by police on 1/6/2026 and since then he is behind the bars. The learned senior counsel appearing for the accused applicant submits that submits that the police has already recovered, recovered the debit cards used as well as the mobile phones. And the investigation is almost completed in the instant case. Therefore, further custodial detention of the accused applicant in the instant case who is behind the bars for last 44 days is not required. It may not be required. Therefore, he prays that the accused applicant should be granted bail. Full stop. On the other hand, the learned Mr. D.P. Goswami, the learned APP, appearing for learned APP submits that there are sufficient incriminating materials of the involvement of the accused applicant as mentioned in the as narrated in the FIR. He submits that the investigation is still going on and there are investigation is still going on and there may be many other persons involved in the instant case and that require and the same is required to be done by the police. Therefore, the accused applicant's custodial detention is required in the instant case. He opposes the bail. He opposes the prayer of bail of the accused applicant. Full stop. CD in the instant case has been produced before this court and the same is perused. This court has considered the entire facts of the case and it is seen that it is prima facie seen that the required documents as well as materials have already been seized and recovered by the police and investigation is at the fact and investigation is on the verge of completion and therefore this court is of the opinion that the accused applicant, since he has already spent 44 days behind the bars, should be allowed to go on bail. Accordingly, it is directed that the accused applicant shall be released forfeit from jail on furnishing of a bail bond of rupees 50,000 with a surety of like nature, subject to the satisfaction of CGM Borpeta, subject to the following conditions. Number one, the accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. Then number two, the accused applicant shall not indulge in any of the activities relating to betting, gambling and betting. Full stop. Next para. Okay, fine. That's fine. In terms of the aforesaid, the instant bail application, in terms of the aforesaid direction, the instant bail application is disposed of. In other case, also the facts are same.
The only minute is being statement of the.
He's behind the bars of 33 days. And another thing is that you can write that this person has been arrested on the implication by this person, Diwan Jahirul, the other person there. Okay, you can write that. No? Other facts are same. Other FIR and everything is same. Only thing is that this person is arrested by being named by this person. Both are like.
May it please your lordship. Lordship, pursuant to your order dated 23 to 2026, the petitioner has already visited the DRI office twice and recorded a statement. On 29/5/2026, show cause notice has also already been issued by the respondent authorities, by the custom department, and wherein he has already submitted his reply also, Your Honor, praying for personal hearing. Praying for personal hearing.
Okay.
To the customs office.
For personal hearing was allowed?
Till now, no communication has been received from their end, lordship.
See, as per direction of this one, what he appeared before the authority. Lordship, there is no consistency between the document submitted by the petitioner in the bail application and the statement given before the authority. Lordship.
There is no consistency.
Yes, Lordship. Lordship, in bail application, he said that there is an agreement between his mother and one Doval Sarkar. But in, Lordship, please to see our affidavit file.
But I mean, he is appearing and I mean, doing
Lordship,
these things, but
please to see.
whether it is, whether that will be relevant consideration, but that you can always,
Whenever.
wait. That always you can look up and take into account, I mean, look into, I mean, in your inquiry, investigation.
No, Lordship, for judicial, custodial integrity is necessary in view of his statement given by the authority, Lordship. And the document submitted before. the
I
authority.
mean, he's cooperating with the investigation.
No, Lordship, may please to see.
Hmm.
Yes, he is cooperating with, Lordship, may please to see the state
So,
taken.
taking him into custody, what else you are going to get in?
Because Lordship, because he initially submitted before this honorable court that the premises from where the illegal substance were seized were not belong to him. But in statement before this court. Lordship. It would be.
No, Mr. Kayal, only thing is that, is there anything really grave which requires his custody?
Lordship, because.
No, what?
This is
What?
my
No, custody, what you are going to do?
Lordship, because the truth has been extracted from the.
No,
petitioner.
Mr. Kayal, see, he is appearing. Whenever you call him, he is there.
No, Lordship.
No, is he defaulted?
No,
When-
Lordship,
huh?
that is
No,
not the.
he has not defaulted.
No, no.
Now taking him into custody, what else you are going to get
No,
get
Lordship,
from
please
him?
to see.
No, if he doesn't give you any document or whatever, I mean, I don't
Lordship,
know,
he's-
if he doesn't reply, whether in custody, how you are going to get
No,
out of that?
Lordship, may please to see the document submitted before this honorable court in bail application and a statement given by him before the authority.
Hmm.
If there is any consistency, is there, Lordship, he is entitled to anticipatory bail.
No, I understood everything. I mean, if he gives some different documents also,
No, Lordship.
while in custody, what are you going to do?
Lordship, because the authority has to extract some facts from his.
Extract how? In custody, you are going to use different different this thing.
No,
Then,
no, because he will be in jail, Lordship.
Hmm?
We have to.
so you keep him, he will go and sit with you for 10 hours. What is the problem?
No, Lordship, that is correct, but Lordship, may please to see the statement given by him and the
No.
document submitted by. Lordship, please to see our affidavit. Lordship. Paragraph 6 and 7 of the statement given by him. Page 3.
1 second.
Question number 6, Lord.
Question number
6 and 7.
6 is what? 6, question number 6. Yes.
On 4.
On 4 to 20, the officer of DRA conducted search at your residential premises and recovered immense sticks of foreign cigarettes
Yes.
from one locked room. What do you have to state? The
Yes.
cigarettes seized from residence belong to Himangsu Bose. He is actual owner of the seized foreign origin cigarettes. I was involved in transporting and storing the cigarettes at my residence on his instruction. I was not aware of dealing in such foreign. Okay, what was there in the bail application?
Lordship, may please to see.
Hmm.
Page 11.
Page 11.
Lordship. He has submitted on agreement.
Page 11. Okay,
Tenancy agreement.
one
submitted.
second. Page 11.
Lord.
Tenancy agreement.
Yes, between Mallika Kharkalari is the mother of the petitioner
Okay,
and.
Doyal Sarkar.
Doyal Sarkar.
Correct. Tenancy agreement. Yes. What is
Lordship,
there?
It was, then he submitted his reply on page 15.
Page 15.
Lord.
So there is a tenancy agreement between one landlord and his mother.
His
Then
mother and the person named.
this Doyal Sarkar is who?
Lordship.
Is he involved? No.
No,
So there is a tenancy agreement.
this is Lordship, our contention is that this is afterthought agreement.
Hmm?
This is after thought, Lordship. In affidavit also, we have also.
30th September 2023.
Lordship, may please to see.
Your allegation is fine, but like how you can prove that it was done? That will be proved, I mean, in trial only. No, and what is there in 15?
Page 15 is the reply to the Soko's notice.
Ah, 15, what does it say? 15, which paragraph?
Lordship, this is a short reply, may entire, I so and so is the law abiding citizen, paragraph 2.
Paragraph 2.
Paragraph 2.
That the rental premises from the where the seizure was affected does not exclusively belong to, nor is under the position of my control. The premises is owned by my mother, Mallika Karikare. So what is the inconsistency?
Because Lordship, in his statement, he submitted that he was involved in trafficking the goods, illegal goods.
Transporting and this thing.
Yes.
So he's admitting certain things.
Yes,
So-
Lordship.
So what is the problem now?
No, Lordship, in bail application, some other statement is
The
there.
bail application, he has stated that like it was mother's premises.
Lordship, entire bail application.
No, Mr. Kyle, I don't think there is any
Then
requirement of
Lordship,
this.
our reply may kindly be seen. Lordship,
Hmm.
I cannot,
I mean, I have heard you. I have heard you.
then Lordship, paragraph 4 of my affidavit may kindly be seen.
Paragraph 4, what is
Page
there?
25.
Attempt to distance himself from the seized goods.
The
Project
in the
in-
tenancy agreement in respect of the room from where the contraband was recovered. However, the said plea, privacy, contradictory and afterthought. The alleged tenancy agreement is unregistered and unstamped, bear no witness signature, contents undated signature is unsupported by the rent receipt or banking transaction. Then let's see, next page. Further, the petitioner himself in his voluntary statement recorded under section 108 of the Custom Act admitted that he was the storing and foreign origin cigarettes in the said premises. Therefore, the defense sought to be raised is self-contradictory and lack credibility.
There is no independent material linking the petitioner with the alleged offence, Lordship. Smuggling, loading, unloading goods, he was not involved and he was not present in the premises when the TRA officers raided the premises of his mother.
So yes, his mother is involved.
No.
So we're going to arrest her. You
Why
arrest her,
not?
you give her a notice. No, she is saying that like he's not involved, mother is involved.
Mother's premises.
The
right?
mother's
She can
premises
give-
means under your mother's control.
No, not in my mother's.
The whose
control.
control then?
In the tenant's control.
Huh?
Royal Sarkar, tenant's control. Those are tenant's control, Lordship.
In his voluntary statement is named some other person. Lord.
Lordship, this person is uneducated, Lordship.
Okay, Mallika Karikari is the owner
Is the owner of the rented premises of the land.
and
Lordship.
it has been given to Doyle Sarkar.
Royal Sarkar in 2023.
In reply to paragraph, in the question to paragraph 6, he says that the residence belong to Sri Himanshu Bose.
There are some inconsistencies, maybe, I mean,
That's my invite to.
maybe some discussion, but like, I mean, he's cooperating, let him cooperate.
He's cooperating. There is.
He's
we are-
cooperating and heard MS your name?
Chandana Sharma.
Heard MS C. Sharma, the learned counsel, according to the accused applicant, also heard Mr. S. C. Kyle, the learned standing counsel, Customs Department. This is an application under section 482 of BNS 2023, praying for release of the accused applicant, praying for PRS bail to the accused applicant in connection with DRI. You write it down from here, no? DRI, so and so. The allegation relates to recovery of certain amount of foreign cigarettes from the premises of
Page 8 is the seizure memo.
from the residential premises of the. You were staying there or not? You were not staying there.
I reside there only with my wife. I'm a Toto driver, Lordship, and my wife is a pharmacist who.
So you are residing in that house, right?
Deciding in that, but whole day I won't be there, your
Okay.
lordship.
On the residential premises of the accused applicant, full stop. Full stop. After the aforesaid seizure of foreign origin cigarettes from the room, the custom authorities has issued summons under section 108 of the Customs Act 1962, 62 to the accused applicant. Full stop. The learned counsel appearing for the accused applicant submits that being apprehensive of his arrest after receiving the aforesaid summons, the accused applicant has approached this court by way of filing the instant instant anticipatory bail application. Full stop. She submits that in terms of the order dated 23 to 2026, the accused applicant has already appeared before the customs authorities and got his statements recorded. Got his statements recorded to the effect that he had replied to the SOCOS notice. Right? SOCOS notice reply.
SOCOS notice was issued on 29/5/2020, 29/5/2020.
Then you have replied or not?
I have replied 23/6.
Yeah, SOCOS notice replied.
I myself went to Shillong and I have submitted the report.
Then you write, he submits that the accused applicant is a auto rickshaw, is auto van driver.
Toto, the e-rickshaw driver.
E-rickshaw driver who resides with his family in the residence. However, he is not connected with the seized material from the premises. He further submits that since he is cooperating with the investigation, he should be allowed to go on. His interim pre-arrest bail should be made absolute. Full stop. Mr. S.C. Kayal, the learned senior counsel appearing for the customs department.
DRI.
Huh?
DRI, not custom. DRI.
It has been written as customs in the earlier order.
No, Lordship, the notices to be issued under Custom Act, but investigation was conducted by DRI.
DRI. So
That-
you are appearing for a DRI.
Lordship.
You write DRI, huh? The DRI has submitted that DRI has already filed an objection to the objection in the instant instant AB application. He submits that there are several inconsistencies in the statement of the accused applicant before the DRI authorities vis-a-vis the anticipatory bail application filed by the accused applicant. He submits that is it your submission that there was some misrepresentation
No, Lordship.
in getting the bill?
No, Lordship, that is not, my
Hmm.
submission is that during the preparation,
Hmm.
he stated something and in bail application something.
Hmm.
He said that.
That's why there are some inconsistencies
yes,
in the statement and
yes.
this thing.
Yes, that will,
And therefore, he opposes the bail, he opposes the pre-arrest bail of the prayer of pre-arrest bail of the accused applicant. Full stop. This court has considered the submissions made by the learned counsel appearing for the parties and has also perused the objection filed by the DRI. Full stop. After considering of all the aspects in entirety, this court is of the considered opinion that the interim pre-arrest bail granted to the accused applicant should be made absolute. Accordingly, the interim order dated 23 to 2026 passed by a coordinate bench of this court has been made absolute. In terms of the aforesaid direction, the instant AB application is disposed of. Much.
Please, your lordship. Lordship, kindly pass over the matter for timing due to some personal difficulty. My senior counsel is not present.
Who?
Due to some personal difficulty, my senior counsel is not
Who is
present.
your senior counsel?
SP Chaudhary.
Huh?
SP Chaudhary.
SP?
Chaudhary.
He's here or not? He's not there. He's in the court or not? Please speak little bit loudly. He's in the court or not?
No, lordship.
So you are seeking an adjournment. Why didn't you mention in the morning itself? On the prayer of the learned counsel appearing for the accused applicant, let the matter be, the matter is adjourned and let the matter be listed in the next week.
CD not received, my lord, sorry.
Mr. Mandal, CD is not there,
Up to that CD was called for actually, up to that CD.
but CD is not received for quite some time.
No, earlier CD was there, my lord, after the CD was called for, yes. Last occasion also CD not.
What have you done, Mr. Mandal?
Lord, nothing has been, my lord. Lordship, kindly see for a moment, my lord.
No. You
Back
just
up
tell
for-
me, what have you done?
Now, the my lord, drivers of the my lord, tractors have been arrested by the my lord, police, saying that they are illegally earth cutting. Now, we are the my lord, four villagers of the said villages, and one of the my lord, petitioner is the brother of the one of the tractors, driver of the tractors. My lord. Lordship, kindly see for a moment, my lord, paragraph 4.
No, Mandal will do one thing. Next week we'll be fixing it. Okay.
Short date maybe.
Next week.
Urgent, my lord.
Heard Mr. M.U. Mandal, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APP for the state. CD is yet to be received. Let the matter be listed on 22nd.
Blessing.
25 also, sorry, my lord, CD not received. Is an interim, my lord.
Is an interim. CD not received. Let the matter be listed on 23rd. Interim order so passed earlier shall continue till the next day of listing.
26 or 23rd and 24th, something,
Why?
some difficult segment.
27th. Let the matter be listed 27th.
Interim order.
On
Interim order.
22nd, my lord.
23rd, 7th. He said.
22nd. That's it, submit, my lord.
You go and appear.
Lordship,
Heard Mr. D. Gogoi, the learned counsel for the accused applicant. I also heard Mr. K.K. Parasar, learned APP for the state. This is an application under section 482 of BNSS 2023, praying for pre-arrest bail to the accused applicant in connection with Nunmati Police Station case number 80/2026 under sections 316(2)/318(4) of the BNS 2023. The learned APC submits that charge sheet in the instant case has already been filed by charge sheet number
62/2026, dated 29/5/26.
It is, the accused applicant was granted interim pre-arrest bail. In order dated 8/6/2026. In view of the submission of the charge sheet, the learned counsel appearing for the accused applicant submits that he should be allowed to appear before the jurisdictional court, full stop. Taking into account the aforesaid, this, it is directed. The instant AB application is disposed of with a direction to the accused applicant to appear before the jurisdictional court for appropriate relief within a period of 15 days. Within a period of 15 days from the passing of this order, from the date of passing of this order. In terms of the aforesaid, the instant AB application is disposed of.
15 days in time may be called.
Hmm?
15 days in time may be called.
What?
In time order is still.
On 15 days you appear, your interim order is still there. You are directed to, till then he may not be arrested, till then he may not be, till his appearance, he may not be arrested.
I know.
Yes. So on the last occasion,
Hmm?
Lordship,
Yes.
22/6/26.
Hmm?
On the last occasion, that is 26/6/26, there was an order for directing to produce the case record in terms of,
Is it there?
No, case record from the
Huh?
trial court Lordship.
Call for the records of the Sanmari PS case number so and so.
A letter was
Where is
received
it?
from the system, the trial court, last page, flag A.
if I may clarify why the case record was called for, Lordship.
So case diary will be there in the.
Yes, there is here, well, it has, but learned council's submission is that in the trial court, an affidavit was filed by the informant. That was called for earlier in earlier occasion, but order was not reflected as such as Lordship. Order was reflected as only case record was called for because the case is under investigation stage. So no case record will be there. Is affidavit is there, Lordship, in the trial court, then that affidavit may be called for.
Exactly, because that order was passed basically taking into note the findings of facts that was recorded in the rejection order by the learned additional session just below in a previous one.
Yeah, correct. Now, why do you want that?
Yes, because at page 27, Lordship, in my application.
Then what is now? Why do you want that? You argue on the case on your own merit.
Otherwise, also I have the
No,
certificate.
but I mean, that is not, I mean, is it required? That the affidavit by whom?
By the informant.
By the informant.
By the informant.
Informant, he is appearing, no? He is appearing for the informant.
Are you appearing for the informant? Okay. So basically, may I submit the affidavit also? I will obtain the certified copy of the affidavit by the informant. That this honorable court wanted to see the affidavit. That is the only contention.
Affidavit is already there.
I have obtained the certified copy.
Place it, then certified copy. What is your instruction?
Till yet, I don't know about this affidavit.
Hmm?
Till yet, I don't know about this affidavit.
Forget about affidavit. What is your instruction?
Instruction, Lordship, there is a threaten is there, Lordship. There is a apprehension of threatening there, Lordship.
But you said in the affidavit that I mean, you have good relation feeling towards Nur Muhammad Sheikh, and therefore no objection in granting pre-arrest bail. That you have stated.
I have to take proper instruction, Lordship. About this affidavit, I don't know till yet.
This is a certified copy. You have a look.
Yes, Lordship.
You have a look. What more you want? I mean, you state something there and like come before this court, then you state something else. That cannot be done.
Lordship, just only yesterday, Lordship, I have engaged only just I filed the book.
No. What is your instruction? Instruction is like to object or not object.
Instruction is object, Lordship.
Huh?
Object.
Then why you have stated before this trial court that you don't have any objection? The victim has appeared. The order also reflects so.
Yes, 27 please.
The victim has appeared in person and submitted an affidavit stating that she has realized that she has lost the case due to extraneous influence and she still has good relation and feelings towards the accused. But your bail was rejected that time.
Exactly. In fact, without even considering the medical report, that was vital. Because what happened, Lordship, in this case, FIR was lost after more than 1 month since the alleged offense. And I have given the specific statement to that effect. So
So you can understand a lady's mental this thing.
because she is my relative, and she continues to be good relation. There's nothing.
You take instructions,
Yes, Lordship, I have to take instruction and I will
you
follow.
take proper instructions.
Yes, Lordship.
Heard Mr. P.S. Dekat, the learned counsel appearing for the accused applicant, also heard Mr. D.P. Goswami, learned APB for the state, as well as Mr.
R. Islam.
R. Islam, the learned counsel, appearing on behalf of respondent number 2. Mr. Islam submits that he needs to take some instruction in the instant case and prays for some time. Let the matter be listed on 22nd.
Obliged.
28.
Hmm.
We have not received the case diary, Lordship.
Hmm?
We have not received the case diary. It's from Gwalpara.
My lord, it is the second time. But I filed my lord, there is a defect in the name of my name also. Wrong name has been given in the FIR. And moreover, my lord, most of the people accused must have been granted bail by the Honorable High Court, my lord. I have annexed the orders of either absolute bail or interim bail. It was a case of, though allegation is the murder, there was a marpit and one person succumbed to injuries. But it is very difficult to say who has given the deadly blow to this person, madam.
That's what the CD is required of. The grievous hurt and attempt to murder was there, Lordship. Two persons died out of the assault.
Yeah, you are named in the affair.
Different name, wrong name. Actually, madam, my name is that, my name is Jahangir Alam,
Hmm.
son of Bomdar Ali.
Hmm.
But it has been mentioned in the Jahanuddin Sheikh, son of Bombar Ali Sheikh.
So the different person, why you are apprehending?
But I'm not apprehending, I have come because earlier it was rejected by your lordship. That's
Hmm?
why. Rejected by your lordship. That's why after that CD was called for.
So
And
CD
I-
will call for the state, Lordship.
And your lordship, I have annexed the orders, my lord.
What is your name?
My name is my lord Jahanuddin Sheikh.
Jahanuddin
Yes,
Sheikh.
Jahangir Alam.
What is the rejection order?
Rejection order, my lord. Here,
Page 21, one is.
page 21.
Page 21.
Yes. Your lordship has granted bail to other co-accused person.
So after the perusal of the CD, it was rejected.
Yes.
Then what is your new ground?
But my wrong name has been reflected. My name is not there. That's why up to date CD may be called for, my lord. I have got no objection.
Okay, a CD is yet to be received. Let the matter be listed after, let the matter be listed on 24th.
Item number 29, 30 and 31, same offense report.
We are waiting for the instruction, Lordship. That may be taken on Monday. We are waiting instruction. In fact, the verbal instruction have been given to me that a fresh FIR has been lodged against the 3 petitioner, Lordship. Fresh FIR.
In item number 31, I was in interim order, and accordingly I have appeared before the IO, Lordship.
This is item number what, 30?
This
29.
29,
30 you have appeared.
31, yes,
How many matters are? 3 matters?
3 matters.
All same FIR.
Arising, yes.
What about 30?
31, 30 is also in not interim, Lordship.
Interim not given.
Not 29 and 30 is not interim.
29 and 30, there is no interim. 31, there is an
31
interim.
is
Hmm?
31, there is an interim order, Your Lordship. 29 and 30, there is no interim order.
Let them go in interim then.
But a fresh FIR has been lodged, your lordship.
Hmm?
Recently, a fresh FIR has been lodged against the three petitioners, your lordship.
On
Fresh.
what press affair? or
On
what?
this, on arms sector law.
Hmm?
On arms side, we have recovered arms from their possession, lordship.
From home.
No, that's a different thing. I mean,
Yes, lordship.
that's a different case.
So let the matter be come
Yes, sir.
up, day after tomorrow, Friday, your lordship, I'll produce.
Okay, let them come. Let them come.
Day after tomorrow, lordship.
Day after tomorrow, no.
Friday, your lordship.
Friday. Friday would be.
Friday,
okay.
Friday.
Then write hard Mr.
G. Fukon.
G. Fukon, the learned counsel, appearing for the accused applicant, also heard Mr. Gogoi. Mr. D. Gogoi, the learned special public prosecutor for Assam Forest Department. Mr. Gogoi submits that he prays for some time to complete his instructions. Therefore, prays for some time to complete the instructions. This prayer is allowed. Let the matter be listed on July 17th.
Very well, lordship.
In time, maybe continuing item number 31.
The item number 31. The interim order so passed earlier, so I'll come to
Oblige.
Oblige.
Please, your lordship. Lordship, after filing this anticipated bail, petitioner number. two
Notice
got-
of, notice of,
Well, they are.
I'm appealing for it.
or you are appealing.
Petitioner number 2 got arrested, lordship, so I am paying bail for petitioner number 1, lordship. CD has been received.
Hmm?
Petitioner number 2 got arrested,
Got arrested. And
pet-
petitioner number 2 has already been arrested.
already been arrested, and
Hmm.
I am paying bail for petitioner number 1, lordship.
Hmm.
FIR at page 10, lordship, translated type copy.
Hmm?
FIR is at page 10, lordship. POXO 4 is there and kidnapping is there.
Hmm.
Lordship, may I read?
Okay, Mr. Sharma?
Yes, lordship. CD is here, lordship.
Hmm. Heard Mr. What is your name?
JS Ahmed.
J.S. Ahmed. Rokibul is the main accused.
Yes,
Lordship.
yes.
Heard Mr. J. Islam.
JS Ahmed.
J.S. Ahmed, the learned counsel appearing for the accused applicants. Then you write, also heard Mr. B. Sharma, the learned APB for the state, as well as Mr. I. Hazurika for the respondent number 2. Then you write, this is an application, you write, this is an application, so and so, so and so, huh? Then write, an FIR was lodged before the Howley police station by respondent number 2 on 11/4/2026, alleging entirely that the respondent number 2's daughter, namely double X, is it about 17 years, 10 months? 10 months, was proposed by accused number on several times for a relationship and harassed her mentally. That when the informant's daughter refused the proposal of petitioner number 1, he started threatening her. Semicolon, that on 26/3/2026 at about 3:30 PM, while his daughter was returning from shopping from Khandakarpara market on the advice of petitioner number 2, accused applicant number 2, the accused applicant number 1 forcibly took her in a Maruti car, and after reaching at Howley Sariali, put her into a bus and took her to Jorhat. That semicolon, that the petitioner number, that the accused applicant number 1 took his daughter to a hotel room in Jorhat and committed rape on her. That on the next day, that is on 28/3/2026, the accused applicant number 1 put his daughter on a bus and sent her to Howley. Full stop. On receipt of the FIR, police registered Howley PS case number 39/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits what is the submission?
Lordship, my main ground is that FIR was lost 16 days later, Lordship. And the reason they have stated that for amicable settlement, they were waiting for settlement. And
What
the-
settlement?
For amicable settlement.
Settlement what? Of the rape?
The complainant was waiting, Lordship. They have stated in the FIR last line, Lordship,
Hmm.
regarding this incident, amicable settlement was supposed to take place socially, and for that FIR was filed late.
Hmm.
Lordship, my submission is that
Okay, I heard you. Mr. The learned counsel present for the accused applicant submits that the FIR was filed belatedly due to the fact that there was supposedly an amicable settlement between the parties. And therefore, he submits that the accused applicant should be granted anticipatory bail at this stage.
they have demanded 5 lakhs rupees, Lordship.
Anticipatory bail, full stop. On the other hand, Mr. B. Sharma, the learned ABP, opposes the bail applications, submitting that there are sufficient incremental materials against the accused applicant of his involvement in the alleged offence. Mr. I. Hazarika, the learned counsel appearing for respondent number 2, has also supported the submission made by the learned APP and opposes the bail application. Full stop. After hearing, CD in the instant case has been received and the same is perused by this court and perused by this
Lordship,
court. After
just
hearing
one-
the submissions made by the counsel appearing to the respective parties and taking into account the materials available on record in the CD, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
Lordship, may kindly.
I've seen everything.
Basic- Medical report may be seen,
I've
Lordship.
seen everything.
Medical has no relevance.
Obliged.
My lord will peruse the office note dated, my lord, 7/7/2026.
Hmm?
Office note dated 7/7/2026, my lord. Video which the
Okay, TCR not received.
LCR is not reserved, my lord. I am been appointed as a legal aid counsel, my lord, in this case.
Hmm.
It's basically jail appeal, my lord.
Okay.
My lord, I have already taken steps, my lord, but that is not reflected in the.
No, let the TCR come, then
Lord,
paperwork has to be
paper will be made, my lord.
required. Mr. Yeah,
AB day, my lord.
AB Day, the
Legal
amicus curiae appointed in the instant case for the appellant. For the appellant is present. The TCR in the instant case is yet to be received. Let the matter be listed after 2 weeks.
Please, your lordship, Mr. JMS already on legs.
Hmm?
Mr. JMS already on legs.
JMA Chaudhary is on legs. Now what is to be done?
Pass over 40 timing.
Bring one leg. Yes, to. Can you? Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after 2 weeks. After 2 weeks. Can you bring one leg? He's on legs. Bring one leg. Half. Yes, so what? Huh? Yes, you can bring it. You're not understanding what I'm saying. Okay, 2 weeks.
Today the leave petition is before your lordship.
Hmm?
We have filed this leave petition for the state lordship.
So we'll issue notice on this.
Yes.
Heard Mr. B. Sharma, the learned APP for the state. This is an application has been filed for granting leave, the seeking leave of leave of this court for filing an appeal against acquittal under sections 378(4) of Code of Criminal Procedure. Code of Procedure in bracket you write section 419 in bracket 4 of BNSS 2023. 23. 23. 23. Is issue notice returnable in 4 weeks. Returnable in 4 weeks to the respondent number to the sole respondent by way of speed post. Full stop. Steps for service of notice to be taken by the petitioner within a period of 3 days from today. Let the matter be listed after 4 weeks.
45. May I please, your lordship. This is leave petition, your lordship, against the
Leave.
leave
You're for whom?
for the complainant,
Hmm?
for the complainant,
For the complainant.
lordship.
Okay, heard Mr. A. Shom.
They are shown.
A. Shom, the learned counsel appearing for the petitioner. Petitioner, full stop. You'll be appearing huh, in this matter? Who is there? Oh, no, this is not. Oh, no, not. You are not. Petitioner, then you write, this is the instant application under section 419 and bracket 4 of BNSS has been filed praying for granting leave to file an appeal assailing the impugned judgment and order of acquittal dated 30/4/2026 passed by the learned court of additional chief judicial magistrate, Sagar in NI case number 19/2021. Issue notice returnable in 4 weeks by speed post. Steps for service of notice to be taken within a period of 3 days from today. Let the matter be listed after 4 weeks.
36.
You filed your objection.
I have not yet filed my objections, Lordship.
Okay, you need some time.
I would pray for some time, and in any case, Lordship, if they are asking for a Lordship bail at this stage,
Hmm?
if they are asking for a bail at this stage, 50% of the sentence is yet to go. So it will be sometime in the month of August. So better we take up the appeal, Lordship.
But if file an objection by
Yes,
the
I
time,
will
if
file.
file an, then we can take it up.
Yes.
Okay.
Already 4 years, 11 month lordship.
Huh?
Already 4 years, 11 month lordship.
Let them file an objection, we'll take up the whole matter.
Yes, yes.
Huh? Heard your name?
J Singfo lordship.
Huh?
J Singfo.
J?
Singfo.
Singfo, okay. Heard MSJ Singfo, the learned counsel appearing for the applicant. Appearing for the applicant. Also heard Mr. R.K.D. Chaudhary, learned senior counsel appearing for NCB. So what is to be written? Senior counsel and
Deputy SGI.
senior counsel assisted by L. Devi, comma, the Deputy Solicitor General of India for respondent number for NCB. For NCB, full stop. Mr. Chaudhary prays for some accommodation to file the objection in the instant case. Full stop. So you'll be filing objection in this IA or like
In
the
the
whole-
IA.
in the IA you'll file in the instant case. His prayer, the prayer of Mr. Chaudhary is allowed. 2 weeks time is granted to the to NCB to file the objection in the instant application. Let the matter be listed after 2 weeks.
37.
I preferred by me.
Lordship, regarding this case, I have a very small request. Our name has been mistakenly reflected in the cause list. We are now no more in direct contact with the present respondent. Notice may issue, Lordship, but kindly our name should be like strike off from the cause list because we have no instructions regarding this present case, Lordship.
Perhaps because they were earlier
Yes,
appearing.
yes, Lordship.
So you can intimate them.
Yes, we tried, Lordship, but we have no instructions. We did
No,
not.
I'm not saying instructions. Try to understand. I'm
Yes,
saying that you can intimate them since you were the counsel earlier.
Okay, Lordship, if they.
No, you were the counsel earlier, right?
Yes,
So you have some responsibilities.
Okay,
You should, you said intimate, you can intimate them that there is a case file against you.
Okay, Lordship, if they engage us, then I'll appear in this present case.
Like, I'm not saying about engage. Engaging is the privilege of the client, right? You can at least intimate them since you were the counsel earlier,
Okay, Lordship.
right? But you are saying that your name should not be reflected.
Yes,
Correct.
Lordship.
Will not reflect your name. And notice will go.
Notice has been-
Only notice has to go, will not reflect your name. And you can intimate them.
Here is a case, Lordship, where Lordship is supposed to grant anticipatory bail to the petitioner. at that point
You're
of time
filing it for what?
For cancellation.
Cancellation of bail.
Yes. Now what has happened is, Lordship, some
Oh.
facts were concealed while moving the anticipatory bail application.
The bail was governed by this court only.
Yes. Now, Lordship had fixed a date for his appearance. He did not appear on that day. He appeared subsequent. That is one violation of the court's order. Secondly, while he was there before the authorities and was questioned, then it appeared, Lordship, that he has been, Lordship, engaged. He is implicated in 3 other cases where also he is on bail. And this was something
Not divulged here.
not divulged here. This was something, Lordship, he was on bail in those other cases, not divulged here. He got a bail here also.
Hmm.
Now, this is an interstate racket, Lordship. This is an interstate racket.
Hmm.
Therefore, Lordship, to unearth the truth, the other materials, Lordship, we need his custody, Lordship.
Hmm. Okay, heard Mr. R.K. D. Chaudhary, the learned senior counsel, assisted by L. Devi, comma, you are appearing as Deputy Solicitor General of India, for DS, for NCB, Also heard
Lordship, I'm M. Bhuya on behalf of K. Borwa.
M. Bhuya on behalf of Mr. K. Borwa. Then you write, the instant application has been filed by the applicant. Under section 483 in bracket 3, stroke 528 of BNSS 2023, praying for cancellation of pre-arrest bill granted to the respondent by order dated 8/4/2026, passed in AV number 87787/2026. Let notice be issued, returnable in 3 weeks, returnable in 3 weeks to the respondent by speed post. Speed post. No, then before that you write one thing, MS Bhuya.
Yes, Lordship.
MS Bhuya submits that they are that she is no longer in connection, no longer in contact with the respondent, and she doesn't have any instructions to appear in the instant case. Therefore, she prays that her name should not be. Therefore, she prays that her name, along with the name of Mr. K. Borua, should not be reflected in the cause list. Full stop. In view of the aforesaid submission, let formal notice be issued to respondent or to the respondent by way of speed post. Full stop. Steps for service of notice shall be taken by the counsel appearing for the applicant within 3 days from today. Let the matter be listed after 3 weeks.
So,
Register to, then you write, register to struck off the name of Mr. K. Borua and M. Bhuya on the cause list. Cause list for appearing for respondent number 2, for the respondent.
so 48
Register to strike off, huh? Struck off, no strike.
There is a delay of 18 days.
Hmm?
18 days of delay.
Mr. Parasar,
We don't have any objection.
heard MSP S. Khatuni, the learned counsel appearing for the applicant. Applicant also heard Mr. K. Parasar, the learned APP for the state. But there is this thing.
For,
Respondent number 2 is there.
for 2 years.
You will have to issue notice then.
Oh.
Ms. Parasar for learned APP for the state, huh? Learned APP for the state. Full stop. This is an application under section 5 of Limitation Act, praying for condemnation of delay of 18 days in filing the connected criminal appeal. Connected criminal appeal. Let notice be issued to respond. Let notice be issued to the respondents. Formal notice to respondent number 1 is dispensed with as Mr. K.K. Parasar, the learned APP enters his appearance for respondent number 1. Steps for service of notice to respondent number 2 shall be taken within a period of 3 days from today. Notice by speed post, huh? Just write speed post. Let the matter be listed after 3 weeks.
49.
May I please as a lordship?
127 days.
My lord, there is a delay of
127 days, Mr. Parasar.
Statutory appeal,
NDPS case.
Lord, I have been pleaded guilty and thereafter, my lord, after fine, I have been lectured, my lord. I have pleaded guilty.
You have pleaded guilty then?
my lord, and thereafter. My lord, the.
Mr. Parasar, what is to be done? If you oppose, then notice will be gone, notice will go, and like if you do not oppose, then I mean.
then delay 127
days.
Let the delay be content, will
Okay.
argue on my.
Okay. Good, fair enough. I heard Mr. A.R. Bhavia, the learned.
Only Bhuya, my lord.
Huh?
Only Bhuya, my lord.
Always it look like bor, so we pronounce bor.
Sorry, my lord.
Mr. A.R. Bhuya, the learned senior counsel, assisted by so and so for the applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. This is an application under section 5 of the Limitation Act 1963 for condemnation of delay of 127 days in filing the connected criminal revision petition. Full stop. The learned counsel appearing, learned senior counsel appearing for the applicant submits that the delay of 127 days is unintentional and the same has been same has been sufficiently explained explained in paragraphs. Explained in
paragraph, my lord, 6 and 7, my lord.
Paragraph 6 and 7, full stop. Therefore, replace for condemnation of the delay. Mr. K.K. Parasar, and APP submits that he doesn't have any objection in condoning the delay of 127 days in filing the connected criminal revision petition. Full stop. Taking into account the aforesaid submission as well as being satisfied with the explanation given in paragraph 6 and 7 of the instant application, the delay of 127 days is condoned, and accordingly the instant IA is disposed of.
Registry to
Registry to register the criminal
registered or revision.
registry to register the criminal revision and list it accordingly.
Blessed, deeply obliged.
Yes, is for condoning delay of only 1 day, Your
Huh?
deal of condoning for 1 days.
1 day,
1 day, your,
only 1 day.
1 days, your lordship.
We heard Mr.
A hawk, your lordship.
A. Hawk, the learned counsel appearing for the applicant. This is an application under Section 5 of the Limitation Act 1963, read with Section 528 of BNSS 2023. 23, praying for delay, praying for condonation of delay, praying for condonation of delay of 1 day in filing the
Criminal revision.
connected criminal revision petition. First, taking into account the explanation, next paragraph, taking into account the explanation. Which paragraph you have stated 1 day delay?
Your lordship, in paragraph 11, 12, I have mentioned, due to medical, due to accident and operation in Narayana Bhavna Hospital, it was
Okay.
late.
Uh,
11 and 12 particularly.
Taking into consideration the explanation provided for delay of 1 day. This court is of the considered opinion that the delay of 1
Your
day.
lordship, and seven medical documentation, seven.
Okay. Delay of 1 day can be condoned without issuing any notice to the respondent number 2. In view of, in terms of the, in view of the aforesaid, the instant IA is disposed of by condoning the delay of 1 day. The registry to register the criminal revision petition and in view of the disposal of the IA and condoning the delay, the registry to register the connected criminal revision petition and list it accordingly. The instant IA is disposed of.
Yes, your lordship. Audit, hearing.
None appeared for the petitioner when the matter was called for. Matter was called for.
2019.
It is seen that the matter pertains to 2019 and on the last occasion, that is on 10/6/2025, the counsel appearing for the petitioner sought an adjournment and the same was allowed. Same was allowed, for the interest of justice, the matter is directed to be listed. Matter is directed to be listed in the last week of July. In the last week of July, with the observation that further adjournment in the instant case shall not be granted.
Me, please, your lordship. Arguing counsel is on legs, your lordship.
Who is the arguing counsel?
Mr. A. Atre.
Hmm?
Mr. A. Atre. Perhaps, your lordship, this matter is ready for hearing, your lordship, may accommodate us with the date.
He is appearing.
No,
No, no, no.
Your name?
Jake Moore.
Huh?
Jake Moore.
Jake Warren. Mr. Jake Warren, the learned counsel, appearing on behalf of Mr. A. Atreya, the conducting counsel in the instant case. Let the matter be listed after 2 weeks, after 3 weeks. After 3 weeks. Finish the work.